Hello, everyone. Good afternoon, now that it's 12 o'clock officially. Thank you for coming here today and welcome to this installment of the Pro Bono Partnership of Atlanta's webcast series. I'm Surisha Ganta, Education Director with PBPA, and today we'll be talking about a topic very important for any nonprofit. We'll be talking about navigating conflicts of interest. I am excited to have with us today Darcy White, partner with Jones Day, to speak to us about the topic. Some of our viewers may be familiar with Darcy already, as she is an amazing longtime supporter of PBPA, both as a volunteer advising our nonprofit clients and as a board member helping to guide us at PBPDA. She's also active in the larger nonprofit community of Atlanta, and I'm so looking forward to hear the great insight that she's going to share with everyone today.
Surisha.
Before Darcy gets into the substance of today's presentation, I would like to share a bit about our mission at PBPA. Pro Bono Partnership of Atlanta provides free business legal services to Atlanta area nonprofits. We do this by connecting small community-based nonprofits with volunteer attorneys such as Darcy, who work with law firms and corporations in the metro Atlanta area. PBPA provides legal insight specifically relevant to small Georgia nonprofits, striving to meet nonprofits wherever they are in their journey and capacity. For example, we provide services to startups through our nonprofit bootcamp, one-time engagements like our Vital Science Forms Clinic, and ongoing one-on-one legal counsel to nonprofits that qualify as clients. In fact, we are currently accepting applications for our next round of bootcamp for any nonprofit that might be interested. So I am going to drop a link to that in the chat right now. So check that out if you might be interested. Next, I would like to highlight our Learning Center. That is a resource that we have off our website that's full of podcasts, webcasts, and articles. And these are available to anyone for free and are tailored specifically to small Georgia nonprofits. If you have a legal question, you can probably find the answer there. So keep it in mind. And a little bit of background about our clients, if you're interested in applying to be a client of ours. Our nonprofit clients are all 501c3s that are in the metro Atlanta area, have staff member, and are serving low income or disadvantaged individuals. Our clients are all otherwise unable to afford legal services. And a little bit of housekeeping. After all, we are lawyers, so we're going to share this legal information. Keep in mind that today's webcast is copywritten, and I will be able to share the slides in the chat momentarily for anyone who is curious about that. And today's presentation is being recorded and will be available on our website in a couple of days. You are welcome to propose any questions to Darcy during this presentation, but keep in mind that this is not legal advice, so please keep your questions pretty general. And if you have any specific questions, reach out directly to an attorney to address that. And with that, I'll hand the mic over to you, Darcy.
Great, Surisha. Again, thank you for the kind words and the introduction. And as you mentioned, I'm a partner at Jones Day here in Atlanta. And what I do kind of for my clients day to day is mergers and acquisitions, but also corporate governance work and general corporate work. And so really excited to talk to you today about conflicts of interest and how we kind of analyze those and what they mean for the organization and how we can navigate a path for our organizations with respect to conflicts of interest. So what are we going to talk about today? So on the agenda, we're going to look at some examples of competing interests. And so those are things that are potentially problematic from a conflicts perspective. It doesn't mean that they necessarily are a conflict of interest, but issues that types of relationships you want to look at. So competing interests. And then, but what actually qualifies as a conflict of interest and what the ramifications are of addressing a conflict of interest, and in particular of not appropriately addressing a conflict of interest. We'll talk about conflict of interest policies, what they contain, the procedures for running potential conflicts through them. We'll look at some common conflicts of interest that lots of nonprofits face. Some will be a little bit more esoteric than others, but all will hopefully be instructive as you kind of navigate the world of conflicts for your organization. And then finally, we'll run through some hypotheticals that will hopefully help us kind of issue spot with respect to conflicts of interest and apply what we hopefully kind of learn through the course of the presentation today. So starting off with some recent examples of competing interests, and these are kind of headline grabbing types of issues that nonprofits have faced in recent years. And it doesn't need to be this kind of grandiose. There are lots of smaller conflicts that you deal with on a day-to-day basis. But these are some, again, like headline grabbing issues that help to inform us about the kinds of things that we should be looking for. The first one is two organizations, American Center for Law and Justice and Christian Advocate Serving Evangelism, were both nonprofits and related, and they were both run by the same family, the Sokoloff family. And their estimates that over a decade, those two organizations provided funding to or business for the Sokoloffs and their for-profit businesses in excess of $60 million. And so, yeah, eye-popping. And some of the bigger points of that were there were $5.3 million in legal fees paid to a law firm where one of the senior members or the senior partners at the firm was a member of the Sokoloff family. One of the nonprofits bought a townhouse in DC and then let the Sokoloff family members live there, or certain members of the family. And then finally, one to note, they made a loan to one of the Sokoloff family members for her to be able to buy a recreational property. And as we'll talk about with conflicts and competing interests, it may not have been an issue. Like they may have kind of run through things where they sanitized these issues. They looked at what the nonprofit was doing and determined that it wasn't a conflict of interest. And so who knows, maybe the law firm was providing services and it wasn't an issue. Maybe they were paying sufficient rent to the nonprofit for that townhouse, but it's hard to understand how a loan to a family member like that could have got through a conflict of interest policy. So again, things that should have been clearly analyzed, and the press and attorneys general were taking a hard look at the Sokoloffs and what they were doing with those two nonprofits. Another example is Goodwill Industries of Omaha, and I want to pause to say that this is not Goodwill in general. This is like a specific nonprofit, a Goodwill in Omaha, and they were constructing some stores. And over the span of 10 years, they handed out $5 million in contracts to companies that were owned by board members. And their employees were purportedly told specifically not to bid out the contracts. And so the architectural firm that they engaged, one of the key architects at that firm was a board member. The CEO of the construction company they engaged was also a board member, and then the board chair was actually the executive vice president of the insurance company that insured the company, insured both during the construction and after. And so it's a lot of bids, right? So so I guess somewhat surprisingly, maybe not surprisingly, Goodwill Industries of Omaha had a conflict of interest policy that said, hey, you need to bid out contracts like this to at least 3 different parties. But the organization ignored that conflict of interest policy, didn't bid out the contracts, and handed these contracts to directors. And so even if you didn't know what a conflict of interest was or have a conception of it, that smells a little fishy, right? But in any event, that was the issue with Goodwill Industries of Omaha. And then another was Wreaths Across America, and it was started by a man who ran a business that made wreaths, and kind of out of fur, and they were in Maine. And he realized going to one of the national cemeteries, I think Arlington, that not all soldiers' graves had wreaths. And so he wanted to be sure that all soldiers' graves had wreaths, which really noble goal and a great cause to get behind. And he had started a nonprofit to get charitable donations donations to fund the purchases of those wreaths to go on all the soldiers' graves. And so, a great and noble cause, but the problem is over the course of years, the nonprofit got bigger. It only kept working with the family business, the family for-profit business, which was Worcester Resources. And so Wreaths Across America was buying all of their wreaths from Worcester Resources, even though other organizations had put up their hand and said, or other businesses had put up their hand and said, hey, we'd like to supply wreaths to Wreaths Across America because we believe in the organization, we can give you a great deal, whatever. And those were kind of ignored. And they kept working with Worcester Resources, the family or the company of the founding family. And also important to note that Wreaths Across America, the nonprofit at the time, is run by the matriarch of the Worcester family, and then the wives of the two sons of the Worcester family served on the board. And so again, a lot, whether it's a conflict of interest or not, and that's not, we're not making that judgment. It certainly seems like it could be. Couple or a few more examples I won't go into in great detail, but some, to things to look at, different fact scenarios where we should be thinking about these types of issues. Baltimore mayor wrote and self-published a children's book and sold it to the University of Maryland Medical Systems, where she was a director and made a good bit of money from it. 18 NRA board members were paid commissions and fees ranging from a few $1,000s to over $3 million. And then the governor of West Virginia formed Old White Charities that paid salaries and other compensation to multiple members of the governor's family. So, what are we talking about with a conflict of interest? And, at base, and I think a good way to kind of frame it and think about it is that somebody's gain equals your organization's loss. And so it's a conflict between the private interests and the official responsibilities of a person in a position of trust. And so you have an individual here, right, that has a competing interest or loyalty. They have a personal interest, but then they also are serving in a role for an organization where there could be a clash between those two kind of different interests and different roles that they're playing. I think the point here to really note is that it's a potential clash. It doesn't even necessarily have to be that a bias influences a decision. It's the potential for the bias to influence the decision that kind of puts us into the world in which we, as nonprofit leaders, need to look at our conflicts of interest policy. And again, at base, it's the use of a person's authority for personal and or financial gain. So, and, again, as with, I mentioned with Wreaths for America, it's perception, or, with the Socklaw family and their nonprofits, what they were doing may not have necessarily been an issue. We can't determine that, us on this call, but it's the perception that is often the reality. And that, conflicts of interest for nonprofits and taxes them to organizations, it's not just the actual conflicts of interest, but often it's the perception of the conflicts of interest. Having a nonprofit maintain its reputation for being a good steward of the public's funds and not having those funds go to any personal, goal or personal interest it's critical. That's critical for your reputation with funders, with the communities that you serve, with your employees, with kind of all the constituents that you want to have a good perception of the reputation of your nonprofit. So what are the interests that we're like, where do the issues come from? Like, if we have a conflict of interest or competing interest that might be a conflict of interest, like what underlies the issues there? So you have potential state law violations, and I'm sure, you all have boards, or you may be on a board and you are cognizant of the fact that you have certain duties to the organization, and chief among those are a duty of loyalty and a duty of care. And frankly, this applies not just to the directors, but also officers and employees. And so you have to put the best interests of the organization first before your own personal interests. And so that's that duty of loyalty. And that's a big part of what conflicts of interest policies are meant to address, is to avoid having those duty of loyalties breached. So in addition, the IRS is very interested in making sure that, these funds that they're allowing to come into a nonprofit and not be taxed, that tax exempt status, they want to be sure that those funds are then being used for the charitable purpose, and it's not private, not going to any kind of private interest. So no private inurement or excess benefit transactions. And we'll talk a bit more about each one of those in just a couple of minutes. In addition to those kind of like specific violations of law, as we talked about, you could have a loss of public confidence and a damaged reputation, and a loss of funding at the end of the day. And, we all know that that's the lifeblood of the nonprofits for, that's what keeps the nonprofits going, right? And having that loss of funding can be the death knell of an organization. So that's why it's so critically important that we understand, are able to kind of spot conflict situations and are able to appropriately run those through our conflict of interest policies. So getting into the IRS and kind of what those issues are there. So the IRS rules require a tax-exempt organization be organized and operated in a manner so that none of its earnings benefit any individual. So there's no private inurement is what we call that. But if private inurement and if private inurement occurs, it's possible that the nonprofit can actually lose its tax exempt status, which again goes directly to the funding of the organization and is a huge risk that an organization could face by not kind of dealing appropriately with conflicts of interest issues. And also, I think important here to note that the IRS doesn't prohibit a tax exempt organization from transacting business with an employee or board members or other kind of interested parties. But the point here, and you'll hear me say this over and over again, but it's important enough that I think it bears repeating. You have to have policies and procedures in place to make sure that these transactions are not unreasonable, and not only having them in place, but then following those policies. Unlike the Goodwill of Omaha that had a great policy, just threw it out the window when they didn't want to have to follow it. So some examples here of private inurement. So unreasonable compensation or unreasonable fringe benefits going to employees, improper personal use of the organization's assets, so not using them for the charitable purposes and for the mission of the organization, forgiveness of debts owed by insiders, and you should always kind of avoid giving out loans as a nonprofit anyway. And if you're in that world, talk to somebody at PBPA before you do it. Your personal expenses being paid by the nonprofit. Again, making low interest or unsecured loans to insiders, not a great idea, but if you do it, know that that's a potential private inurement issue. And then purchases, sales of property, or rental transactions between nonprofits and insiders that are not at arm's length fair market transaction, or that are not arm's length fair market value transactions. And so we'll talk a little bit more about those and dive into some examples a little bit later. So even there, and there's not just kind of this private inurement issue that could then kick you into a world where you lose your tax exempt status, but there's also this kind of other potential, let's call it a stick that the IRS can use to make sure that folks aren't having kind of the public charity resources go to private causes. So there's a rule that says no excess economic benefit may be provided to a disqualified person. And what a disqualified person is anyone that's in a position to exercise substantial influence over the tax exempt organization or kind of related entities. And that penalty that can occur in this situation is intermediate sanctions. And again, it stops short of actually saying that the organization is going to lose its tax exempt status, but it does include significant economic penalties for both the organization and the person receiving the excess benefit, and the person receiving the excess benefit has to pay it back to the organization. And so that's obviously a situation you don't want to find yourself in. But this kind of safe harbor to get to avoid intermediate sanctions requires, and the IRS has kind of laid this out, that the terms of the deal have to be approved in advance, not after the fact, by an authorized body of the organization that's made up of people who don't have a conflict with respect to the potential transaction. That authorized body has to rely upon good and comparable data to make sure that there was no excess benefit. And then that authorized body has to adequately document the basis for the decision, the data it used, the decision it made, and whether that's, whichever way that goes, they need to carefully document that determination. And this is again a theme you'll hear over and over again, and this is kind of the basis for your conflicts of interest policy. We'll talk a little bit more about that in the procedure, but you got to figure out what the conflict is. You have to have a body that's not interested kind of negotiate it, understand it, come up with terms that they think are appropriate. They have to have data to make sure that it's something that's good for the organization and not better than what they could get elsewhere. And then it has to be documented. So again, this will be a theme that will come up over and over again during the course of the presentation.
And Darcy, if I could jump in before, we're going to have a question that we're going to propose to the audience. But I just want to highlight, as Darcy was talking about the IRS and conflicts of interest, we had an audience member ask, are there, if we have a form, conflict of interest policy?
Yes.
PBPA doesn't have one that we share, but the IRS actually has one. And normally I would never, ever, ever tell our clients, go Google or go to Google and just search up a form. But in this case, if you look up IRS conflict of interest, I think it's form 1023 Schedule A. The IRS, this is so important that the IRS even provides a sample that nonprofits can use.
Right. And you don't have to have one, at least per the IRS, but you should absolutely have one.
And now to give the audience a moment to kind of think about what Darcy has said. And we have a hypothetical for you guys. Let us know what you think awesome nonprofits should be doing in this situation. We'll give you all a couple of minutes to take a look at that question and share your thoughts. Thank you, Emily, for sharing the link with everyone for the conflict of interest policy. And I think maybe we can go ahead and close up that question and see what the audience thinks awesome nonprofit should do in this situation. What do you say, Darcy?
I think that that's great. I think you guys are like way ahead and maybe you don't even need this presentation necessarily. So I think that, well, we're actually tied between C and D. So the awesome nonprofit should consider hiring Best Renovations, but Louise should not participate in discussions regarding the hiring of the firm. And then that was kind of tied with the board should consult their conflict of interest policy. And C may be right. That may well be and probably is going to be something that the board is going to want to do in this situation. But the number one thing that they should do, and again, we're going to beat this drum, that the organization should consult their conflict of interest policy and follow all of the requirements of that conflict of interest policy. So I think, and Sarisha, I'd be interested to hear if you think differently, but I think the right answer, the most right answer is D.
Yeah, that's the most right answer. I agree.
Yeah. Great. So we'll go on with the presentation. And, again, and I mentioned this earlier, and it's not like conflict of interest transactions are outlawed. You just have to make sure that they're correctly sanitized because one of these competing interests may actually be something that the organization wants to take advantage of. So there could be a conflict that, is a potential business arrangement that doesn't mean the business arrangement, it's not in the best interest of the organization. As long as the organization follows a good conflicts of interest policy and the procedure and documents those steps, and the arrangement may be the correct choice and can be defensible to both the IRS and to donors and to the Attorney General and anyone else that has an interest in the organization. But the key is to do an independent, and I would also say honest analysis and decision-making process and document that analysis and decision. So, again, the purpose of a conflict of interest policy is to protect an organization's interests when it's contemplating entering into a transaction or arrangement that might benefit or, again, have the appearance of benefiting the private interest of a director, an officer, or a key employee of the organization, or frankly, anyone else that has the ability to influence what the organization does. And it's more than just making sure that the nonprofit assets are used for a charitable purpose. It's guarding against inappropriate private benefit, private endearment, as we were talking about earlier in the presentation. And this grows out of the duties that directors and officers have to the organization, as we mentioned, the duty of loyalty, and to make sure that the organization is being served above any personal interest. And this good conflict of interest policy really helps a board and other members of the organization navigate these potentially tricky situations that can have those types of ramifications. So a conflict of interest arises wherever there's a personal or professional interest of a board member that is potentially at odds with the best interest of the nonprofits. And these situations are really actually pretty common. And again, they're perfectly acceptable if you follow the policy and you go through all of the various procedures. And that's, you have to know when and how a person discloses a potential conflict of interest in the policy. And you'll see this in the one that was linked, when, how, and by whom the material facts are discussed, who the people are that are making the decisions with respect to that potential conflict. And those people will be people that don't have the interest, which is hopefully pretty obvious. And whenever you have someone that does have that type of an interest, you have to be sure, and the conflict of interest policy will say that that person has to recuse themselves or excuse themselves from the discussions. They can't, discuss the arrangement or vote on whether it is a conflict of interest, how the board should proceed or how the organization should proceed with respect to that potential transaction. And then finally, that conflict of interest policy will cover when and how the process is documented, which is again a very important part of this for purposes of evidencing that you're doing the right thing. So digging more into the, kind of the conflict of interest policy, conflict of interest policy in general, the definitions of interested persons and financial interest, we'll cover that more in just a minute. But the process, and again, it's a little bit repetitive, but again, very important to have this squarely in mind. You need to first be sure, and we'll talk about disclosure a bit more in a moment too, but the very first thing is once that person identifies that they have a conflict, you've got to get them out of the room. They can't be involved in the discussion. And then the board needs to have an open and honest analysis, and then an independent and honest decision-making process that's based on data that they can point to. And they have to keep records and document that. And let me kind of give you like an example to kind of ground this in reality. So say you run a nonprofit and you need to buy new sports equipment for your after school programs. And you have a board member that owns a sporting goods store, let's say, and they've offered to sell the equipment to the nonprofit. And it may be a great deal, and very likely it is a really great deal that they're offering because they're invested in the organization and they want to provide it at a low cost to advance the goals of the organization. And again, that may well be the case. We're not saying that it is a problem, but you've got to run through the steps to make sure that it isn't a problem. So you take that person, you get them out of the room, and then the rest of the folks that are making the decision that don't have any sort of an interest, they need to go to Dick's, they need to go to Academy Sports, they need to go to other kind of independent sporting goods suppliers and get other quotes to be sure that the cost of those of that equipment that's being offered by the board member is no higher than, and ideally lower than, those other potential providers could give. And then you kind of document that all in the corporate record. The board makes a formal resolution moving forward with whatever they decide, whether, gee, we got a better deal with Dick's, like you document that and go forward, or you say we couldn't have possibly gotten a better deal than what our board member was offering us, so we've decided to go forward with that particular transaction. So moving again into the definitions and getting a little bit deeper there, who is an interested person? I think the obvious ones are directors and officers and key employees. But it doesn't need to be somebody that has like that day-to-day active role. It can be things like significant volunteers or significant donors. And so these are the people that have sway with the organization that can kind of direct the organization in one way, shape, or form. And also you have to kind of include the people that are around those people, including their family members. But you have to have, for it to be a problem, you have to have an interested person. But then you also have to have a financial interest. And so what is a financial interest? So a person has a financial interest if the person has, and this is directly or indirectly through business, investment, or family, an ownership or investment interest in any entity or a compensation arrangement with an organization or with an entity or an individual, or if they have a potential ownership or investment interest in or compensation arrangement with any entity or individual. So it could be something that's coming down the pike, and all of these things are things that you would take into account in determining whether an interested person has the potential or an actual financial interest that we need to think about from a conflict of interest perspective. And so, again, like kind of bringing that down to an actual example. So let's assume that I'm on the board of Awesome Atlanta Area Nonprofit. We'll call that AAA, and I'm an interested person for AAA. And AAA is thinking of entering into a contract with Big Bad Business, and I'm a co-owner of Big Bad Business, or maybe I'm just a consultant to Big Bad Business, or maybe my kid works at Big Bad Business. At that point, I'm an interested person. And then there's also some sort of financial interest that I have, either directly or attenuated with Big Bad Business. And so at that point, AAA needs to step back, go through the conflict of interest policy. I need to be kicked out of the room, and then it needs to be analyzed in accordance with the conflict of interest policy. So, we talked about kind of what kicks off needing to run through this conflict, and in a lot of ways, we're relying on our employees and our directors and our officers and other key folks that are involved in our organizations to self-report these potential conflicts. And so how do you get to disclosure? Well, when you bring somebody on, when somebody's onboarded, they're brought onto the board, key employees or officers are hired. Part of what's in your conflict of interest policy will be a disclosure with respect to potential actual or potential conflicts with respect to the organization. And so when you bring folks on, you ask them to sign that conflict of interest. They sign them a signed piece of paper, says, hey, I understand our conflicts of interest policy. I don't have any actual or potential conflicts of interest. And that's great. But then you have to periodically update that as well. So each of your board members and officers, employees should be re-upping that certification each year. And they should be signing, again, that declaration, and it should be put into the record books of the organization. So you have kind of an initial and then an ongoing disclosure with respect to potential conflicts. So as I talked about earlier, we'll get into talking about some of the more common conflicts of interest that pop up and that organizations face, and I've certainly seen these. I know Sarisha and Randy and others have seen tons, but you want to be sure that there's no improper personal use of an organization's assets, and that's personal is a broad term, and that could be another organization's interest. You often have nonprofits that are born out of for-profit. So, some for-profit company is providing some service to the community. They realize that there's a certain segment that can't afford the services. And so they start a nonprofit that can then fund the provision of those services for folks that couldn't otherwise afford it. Really great, it's a relatively common construct, a great goal to have, makes total sense, but then it requires a lot of careful thought about how to keep those two organizations separate. So, an example is that the mailing list of the nonprofit can't be used for the for-profit. So the for-profit can't say, hey, nonprofit, give me your mailing list. And that can include donors and officers and directors, and then send out, a mailer advertising the services of the for-profit's business, because that would be an inappropriate use of the mailing list of the nonprofit. Again, also uses of personal equipment for personal use or across between organizations where there shouldn't be that flow back and forth. Another example is that often comes up is personal expenses being paid by the nonprofit. So, say you have a board meeting for your nonprofit that's happening in, I don't know, North Carolina for a retreat at a cabin or something. And it would be great for the spouse to be able to go with the director, which it is great. It just, you can't have the nonprofit pay for that because that's not going to the charitable purposes of the nonprofit. Spouse could pay for their own way. We talked about that, it's never a good idea to give loans as a nonprofit, but giving low interest or unsecured loans to insiders and the forgiveness of debts owed by insiders should be avoided. It doesn't mean that you can never do it, but you should do it carefully. It should go through your conflict of interest policy, and you should absolutely get guidance of somebody at PPPA before you do so. Going on with some more common conflicts of interest. A board member performing professional services for an organization, like we talked about starting out with the Sokolow family, the law firm there provided $5.3 million in legal services to the nonprofit. And that may be fine. But again, that's a clear issue where you may have a conflict of interest. You need to get that interested person out of the room. You need to get other quotes to make sure that, that the person that is interested actually is a good person and maybe even the best person to do the job, but then also that they're doing it for a fee or remuneration that is no more than you would have to pay to anyone else out there for kind of arm's length transaction in the marketplace. And to be sure that you are in that situation, you've got to go out and get quotes from other people. And I think another something else to note here is that if you have a board member that's the only person that can plausibly provide a service to the nonprofit, and that's not just a one-off situation, you're going to have an ongoing engagement with that board member. At that point, it may make sense to step back to determine whether or not that person truly should be on the board, or if they should be serving the organization in some other way, kind of as a consultant and advisor in some other fashion, because you're going to have an ongoing conflict that you have to continually address and justify and document. And so it's just something to think about. Another common situation is that a board member proposes that a relative or friend be considered for a staff position. That person may be absolutely wonderful for the role. They may be willing to take the role for, very market compensation. And it may be fine, but that's another pretty good example or, pretty common example of when you need to run this through a conflict of interest policy and procedure. Another one to look out for is donations by board members that are really benefiting the board member more than the nonprofit, like a donation of a house, right? That sounds great in theory. Like the board member says, hey, I want to give you, my grandmother's house who just passed away. Maybe a wonderful opportunity for the organization. But if you visit the house and realize that the house, the roof is caved in and it has to have a paint job and the yard's overgrown, for that to be anything that's going to benefit the organization, it's going to require significant investment by the organization to get that asset to a place where it could be marketed and sold. Is it worth it for the organization, or is it just like helping that board member get rid of this house that he just didn't really want to have to deal with anyway? And another situation I've seen happen is that there was an offer of a donation of land, which, just vacant land, which again sounds great, but turns out that there were environmental issues with that property. There was a prior release of like hazardous chemicals. And so having that would require immense amounts of money to clean up and would have ongoing exposure for that nonprofit. So again, not something that the nonprofit, not something that ultimately benefited the nonprofit more than it benefited that interested person to get rid of that piece of property. Talking about, kind of like purchase and sales of property and purchase and sales of goods and services between the nonprofit and insiders that are not arm's length and fair market value transactions. Some more examples here, as I mentioned, we would talk a bit more about. Like a board member may want to lease a building to a nonprofit, and this is relatively common coming out of the pandemic, right? We had a lot of vacant office space, and so if you had a board member that said, hey, I'd love to give you, give the nonprofit office space to rent, and it may have even been at a great rate. And that may well be something that the nonprofit wants to take advantage of. But again, you go back to that conflict of interest policy, and you have to like take that person out of the room, and you have to look at all of the various factors that go into moving a nonprofit, right? Like even if you're going to have a lower rental rate, query whether or not it's ultimately beneficial to the nonprofit, like the costs of moving, kind of any of those types of things. You have to take all of that into account to figure out whether ultimately it's the best thing for the nonprofit. You need to look at other rental spaces to see if you can get even a better deal from some other, kind of office location around town. So again, you really have to dig underneath, and things that can look like they're a great deal for the organization, kind of on the face of it, you have to really dig deep and make sure that that's the case when you take into consideration all of the various tenets of the transaction. We've talked, a bit about a lawyer who wants to provide services for a fee to a nonprofit. Again, you got to go out and get quotes for others. Make sure that's the right person to do the job, and they're doing it at no less than kind of what you could get out there in the market for other folks. And this is an interesting one, this last one. So a vendor who does landscaping for the nonprofit offers to landscape an employee's yard free of charge, which how is that hurting the nonprofit necessarily? Like that seems like that's fine on the face of it. But again, you have somebody who's an interested person, that employee at the nonprofit, who is getting something of value, and it's based on the relationship that the nonprofit has with this landscaper. There's probably no way that the landscaper would provide that service to this employee, but for the relationship between the nonprofit and the landscaping company. And so again, it's that employee getting something for its own personal benefit, from something that is supposed to be necessarily that would be the organization's benefit, ideally. So here's another example that comes up relatively often. So a nonprofit needs help to develop a website, but its funds are limited. A board member arranges for her husband to provide the service to the nonprofit for a very low fee. Again, this sounds great on its face, but you have an interested person, and you've got to kind of run through the conflicts of interest policy and procedure, including, going out to get quotes from the market for other folks who could provide these services, and making sure that the husband's services are coming in, at a price that's at or below what you can get from other folks in the market, and that he's good enough to do the job, which hopefully goes without saying, but that's another important consideration. But here, again, you have to look at the totality of the business arrangement, and it's not just the fees here too. Something else that the nonprofit needs to be very focused on is who owns the kind of fruits of this labor. So, the website that's developed, does the nonprofit have full unencumbered ownership of that, of those rights? Do they own the domain name? Do they, if the husband is going to get the domain name registered, is he going to transfer that over to the nonprofit? Are all of the intellectual property rights and what he's producing going to be owned by the nonprofit? And that's another thing that's incredibly important to look at. So, again, going down into the layers of that business relationship to make sure in total, it's a good deal for the nonprofit compared to what they could get elsewhere in the market. And again, with these next couple, that you have an employee's daughter who wants to sell insurance to the nonprofit. She'll get a big commission if she does. The executive brother or executive director's brother is going to paint the facility because, hey, he's available and we need to get this done fast. Again, those may be perfectly fine, but you've got to go out there and get other quotes to be sure that this is an interested transaction or a competing interest that doesn't fall into the world of conflict of interest and become problematic for the organization. So, yeah.
I wanted to hop in with a question from one of
Yeah.
our viewers, which I thought was an interesting question, just because it's an analysis of what is the financial interest. And the question they ask is, what if a board member, or what if an individual has their own nonprofit organization, and they're also a board member of another nonprofit organization, and they're interested in applying for a grant together? Is there conflict of interest, or how should they determine if they should even be applying for grants together if they have this relationship?
A really interesting question. Trish, I'd be interested in your take, but I think if you had both boards, and I think you would, out of an abundance of caution, kind of run it through a conflict of interest procedure, and both organizations should look at it. And be sure, kind of if they're going to be splitting some grant monies, then you need to kind of figure out what goes to each organization. And it probably should be people that aren't involved in both organizations, because you're going to have a competing interest, right? Like if you serve on the board of one nonprofit, you started another nonprofit, it's going to be hard for you to pull yourself away and not have some sort of influence potentially for either side. So I think that person that crosses both should step out, and the board should go through and make sure that they've come up with a negotiated arrangement that makes sense for both organizations. But I'd love your take on it too.
Yeah, I agree with that analysis. I think they could go in and both apply for a grant, for example, but the interested the party that has an interest in both organizations, that individual should kind of abstain from those decisions and that process.
Yeah. And it's hard, right? Especially as a founder of an organization to do that. But at the end of the day, that protects both your organization and the other one from claims that there's a conflict. But yeah, really, really great question. So we'll run through some hypotheticals, and there'll be actually some similar themes, I think, with these hypotheticals. So Nonprofit for Success's founder writes a book about her life journey and experiences, including how she overcame homelessness and a lack of education, and includes stories of helping others to overcome these issues as part of her work through Nonprofit for Success. Founder wants full copyright ownership of the book and all proceeds from the sales of the book, but she does want to donate some of the proceeds from Nonprofit for Success because she's obviously so invested in the organization. So how do we analyze this hypothetical? What are the issues at hand? If you want to go to the next slide, to talk, perfect. So, it is the founder's life story, but some of it came to her because of Nonprofit for Success. And so she's been doing things for Nonprofit for Success and was learning things, and those things that she was doing for Nonprofit for Success and learning from Nonprofit for Success and the work that she was doing really belongs to Nonprofit for Success because they were paying her to do a job. And so what you have to figure out is kind of what part of it belongs to Nonprofit for Success and what belongs to the founder. And so, let's say that there's a third of it. We look at it, we take her out of the mix, the board talks about it. It sounds like it's probably about a third that belongs to Nonprofit for Success, and the rest is kind of the founder's own personal journey. And at that point, you've got to have somebody negotiate with the founder. You have to have disinterested folks. And this means that it probably needs to be, members of the board who don't have a family relationship with her, aren't really good friends with her, like however you want to do that, but it has to be somebody that doesn't have another significant relationship with this founder to negotiate with her to come up with some sort of contract about who gets what. And then the nonprofit would likely enter into a license agreement where the founder would agree to pay a third of the proceeds. If that's the third is the number that's agreed of the split, then a third of those proceeds really should go to the nonprofit. And again, you want to follow the policy and create this kind of record for an arm's length transaction that's appropriately documented via contract, a license agreement with the founder. And then also importantly, the entire board minus the founder, whether she serves on the board or not, she wouldn't be active in that decision, but the board needs to have a resolution where they kind of walk through the process that they went through, why they arrived on the arrangement that they did, and how they documented it. So again, documenting how you went through that potential conflict of interest to sanitize it is incredibly important. So the next hypothetical, Executive Director Joan works for Healthy Living Nonprofit. Joan is an RN who spent 10 years specializing in nutrition and advising patients how to live healthier lives. As ED of Healthy Living for the past 5 years, Joan has developed many innovative programs to teach parents and children How to Live Healthier Lives, and has even been recognized by the President of the US, including for these programs. And Joan is approached by a speakers bureau to contract with the Bureau for speaking engagements. Joan's salary for Healthy Living isn't that much. She doesn't take a big salary because she really wants to help the organization thrive. So this contract and the money that would come in because of these speaking engagements could really help her out. So the question is, can Joan sign the contract and take money from speaking engagements? And so this is a relatively complicated analysis, and so we'll walk through it on a couple of different slides. But the critical question is, like, what is Joan being asked to speak about? Is this really more about the expertise she gathered over 10 years as an RN, addressing these issues before she joined Healthy Living? Or is it more or at all about the programs that she developed as ED of Healthy Living? And so, what is that knowledge that she's leveraging and providing in these speaking engagements? And again, who owns that knowledge? And it's not dissimilar to the prior hypothetical that we walked through. So, how do you deal with this? You also have to think about other factors. There's a third party here. With the other one, it was really just, Joan and the nonprofit, but here, I'm sorry, I forget the name of the prior hypothetical, but the founder in the prior example and that nonprofit, but here we have Joan and Healthy Living, but also the Speakers Bureau that's in the mix. And many of these speakers bureaus actually won't contract. They'll only contract with individuals, and so they may not even contract with Healthy Living. So that may well be the situation that Healthy Living finds itself in. Ideally, we figure out, kind of what portion of what Joan is speaking about is really attributable to Healthy Living and what she's done for Healthy Living. And Healthy Living has a contract with the Speakers Bureau where they get compensated and for in full for what Joan is doing, because she's there kind of as a representative of Healthy Living. In that situation, it wouldn't be out of the question for the board to take a step back and say, gee, Joan is now speaking on behalf of the organization and is bringing in extra money because of it. Should we increase Joan's salary to kind of compensate for this additional service that she's providing to the organization? Or, if there can't be a contract between Healthy Living and the Speakers Bureau itself, then there has to be an arrangement with Joan where the money comes back to Healthy Living, at least a proportion of it that's related to the kind of stories and information and learnings from Healthy Living that Joan had that's being leveraged in those speaking engagements. So again, it's, kind of stepping back, figuring out what the situation is, what should be going to this individual, what should be going to the nonprofit, making a contract with the appropriate party that reflects that, and then the board walking through again and making sure that they're appropriately documenting with board resolutions and contracts those arrangements that they've determined to be in the best interest of the organization. All right, so this one's a bit more of a common situation, this third hypothetical. So Michael's on the board of Stop Cancer Foundation. SCF is currently looking to hire a products company to put its logo on a variety of items it plans to sell as part of its marketing and awareness effort. So merch that can then be sold for to benefit the organization. Lots of nonprofits do it. It's a great idea. Michael's wife, Lisa, owns a company that produces those types of products, those branded merch products. Michael believes Lisa's company will be able to give SCF a great price and suggests SCF use her company. What should SCF do? And hopefully the first thing that comes to mind is that SCF should look at its conflicts of interest policy and follow it to the letter. So SCF should certainly consider Lisa's bid. And this goes back to kind of the question that Sarisha shared, right? Like, yes, they should consider it. It may actually be a good thing, but you got to go through all of these other steps that are in the conflict of interest policy before you sign off one way or the other. So SCF should go out and gather other bids from a few different providers of this type of product. Michael, importantly, and he said, hey, this is my wife's company, but hopefully when he did that, he said, hey, I potentially have a conflict here and I'm going to recuse myself from participating in the decision-making process and leave it to everyone else that's on the board to figure out whether this is the best thing for the organization. And then SCF should analyze all the options, and that independent decision-making body should make an independent and honest decision and shouldn't kind of give any weight to, gee, wouldn't it be great if we were able to use Lisa over these other companies, even if those other board members know Lisa. Like, you've got to have an honest and independent decision there about the best path forward for the organization. And then finally, and again, beating the drum, that SCF has to document that they took the above steps, kind of all of the things that they considered, including competing bids and why and how they made that final decision. So our last hypothetical is, again, a relatively common situation where you have a for-profit and a nonprofit that are kind of linked. Stephen is a mental health counselor who offers some of his services for free through the nonprofit he founded, Helping People Corp, and some for a fee through the for-profit corporation he owns, Making Money Corp. In addition, Making Money Corp and Helping People Corp share office space and office supplies, and the websites link to one another. Is this permissible? What are the issues to consider? So, again, this comes up a lot. It's often great that a for-profit entity forms a nonprofit to help provide services to others who may not be able to afford them otherwise. But you have to have a clear separation of assets and opportunities in the situation. And so if the for-profit uses assets of the nonprofit, then it should be compensating the nonprofit. It has to be arm's length. Of course, the for-profit can provide things for free to the nonprofit. That's great. And that's often the way it works, but you just have to make sure that that flow doesn't go the other way. So there, again, a clear delineation of what the assets and opportunities are between the two entities, like, when are services free and when are they for the for-profit arena? If there's say an income level below which the for-profit provides the services, then that rule should be followed without exception. And again, bright line rules are helpful, and the for-profit can promote the nonprofit, but it can't be the other way around. So you can't have the Making Money Corp sending out a blast mailer or an email blast to Helping People Corp's mailing list of donors, et cetera, saying, hey, wouldn't it be great if you could come get services from Making Money Corp? And again, the board is really at the end of the day, the body that is going to need to kind of look at this. The board of the nonprofit is going to need to be the guardians here, and they need to be sure that there is this clear separation of assets, clear separation of opportunities, and that there's no kind of crossing over that's inappropriate where the nonprofit and what it is doing is benefiting the for-profit. So that's it. Hopefully that was helpful and answered more questions than it raised. But that being said, happy to take other questions. Risha, I don't know if any came in over the chat.
We do have one more question. This is the individual who's asking, they have therapists on staff. And some of those therapists who are on their staff also have their own private practice clients outside of the nonprofit organization. But not that many, like 2 or 3 clients. This individual is asking, the nonprofit is paying for these therapists' license fees. So what is fair for the nonprofit? Should the nonprofit be covering the entire cost of the licensing fees? In a situation like that, is there a conflict of interest if the nonprofit is covering all the fees for these?
I think I would have some more questions about that. On the face of it, I would say that maybe the nonprofit should only be covering a portion that's attributable to kind of the amount of services it's providing to the nonprofit versus the amount that the therapist is kind of getting through private engagements. I think that's a good question. I think we want to kind of like have an offline conversation about that with counsel.
Yeah, and I think it's also a question of how much are they providing for the nonprofit? Do they normally provide services for 100 clients at the nonprofit, and then they just have 2 or 3 outside?
Really good point.
So it's kind of, as so many questions, it's really based on this case specific.
That's right. And it's complicated. And it doesn't mean that there's not multiple right answers, right? But that's kind of why you have this conflict of interest policy, and you've got somebody that can decide it, and it probably needs to be the board that looks at this and figures out kind of
Mhm.
how you split it up if you do.
Yeah, that's a great point. And I'll give folks a little bit more time to see if they have any more questions. And while we're waiting for any additional questions to come in, I first want to say thank you, Darcy, so much for sharing your time and expertise with us. And thank you for the audience for joining us and your great questions. I just want to point out that we'll be having another webcast in a couple of weeks on September 4th. And we'll be talking about several changes that have recently been happening in employment law, such as new overtime rules and new guidelines on discrimination. And I just put a link for that in the chat. If you would like to register, you can go ahead and do that. And I'm not seeing any more questions, Darcy. I think with all your hypotheticals, we covered a lot there, so it was fantastic.
Well, you know who to reach out to, and that's Sarisha and the team at PBPA if additional questions pop up. And you're very welcome, Sarisha. And thank you for your input, and thanks everyone for joining, and have a great rest of the day.
All right, take care, everyone. That's it for
Thanks
this
all.
installment.
Bye-bye.
Bye.